Thank you, Arjan, for joining me for this conversation, and on a Saturday as well. But I gather that you are just as busy now as you were before you stepped down from the Indian Supreme Court.
Yeah, actually, I can only say that yes, I have not retired.
That's
There's no
excellent.
feeling of retirement. I still continue to do my work as I was doing as a judge. So maybe in a different capacity, but yes, there's no sense of retirement at all. No feeling of retirement at all.
That's excellent for you. You've had a very long and distinguished career at the law. First, well, it goes back to law school. I've heard stories of how you were a gold medal winner in your law school days, and then you had a long career as a counsel. And the senior counsel today talk about how they were instructing you when you were at the bar practicing as a counsel. And of course, then you went on to become a judge sitting in the Delhi High Court and also in the Supreme Court. And you quite recently stepped down from the Supreme Court. Of all the different roles that you've played so far as a counsel and a judge, which bit of your career has given you the most satisfaction so far?
Yeah, let me first tell you in brief, of course, my journey from school days till, education, and then in profession, then judge, and then coming back. I tell you, till fifth or sixth standard, I was very average student and was even a shirker, if I may say so. But I don't know, in my sixth class, sixth standard, I could get first division, which used to be 60% marks. So I was little thrilled. Oh, I can get 60% marks. And I started taking interest in studies. Seventh, eighth, I improved further, seventh, eighth standard. And from 9 to 11, in those times, we used to have not 10 plus 2, but up to 11 class in India or in Delhi. So, but then 11th, we used to have board examination, which are now in 12th. So I came in merit list and I was third in entire Delhi. So there was no looking back thereafter. I started getting scholarships in my BCom. Again, I was merit holder in Delhi University. And when it came to law, at that time, what happened, I rather almost set record in the sense that we have 6 terms in 3 years law course. I came first in all the 6 terms and I
Oh,
topped in all the
amazing.
6 terms. So overall, I was a topper, no doubt about it, and a gold medalist. Same continued in LLM also. So sometimes when as a judge, I used to go to various colleges, etc., and to give lectures wherever I was invited. So many students would ask me that how you could achieve this kind of, milestones as a student. So initially, I used to tell them that look, it is hard work, it is your, patience, and that is what you will pay, and your honesty, etc. But then I started thinking that look, when it was asked to me so many times, but let me tell you, and that is my message also. I thought that no, in law, maybe there were some students who may be better than me. Still, I topped in all the 6 terms. What could be reason? So then I thought that there is some plus factor in addition to all what you can do, and what that plus factor would be. And my thinking is, and my hypothesis is that this plus factor is the blessings of your parents, the love of your teachers and your colleagues, and blessing of the God. And I think that was in abundance with me. So my father was also a senior counsel in unlike in England or in your Singapore we call Queen Counsel. Here it is senior counsel. My father was a senior counsel, so I started practicing. Initially, I joined somebody else who just I don't know, many would be knowing Justice Kirpal, who, but within few months of my joining him, he became judge of the Delhi High Court. Then he became Chief Justice of India as well later on. But then I started practicing with my father only. But to tell you, normally it is said that now one should not work with father, etc., because the father would be little indulgent. But my father was strict disciplinarian. And one another good thing in him was that his ethical level and his morality, etc. in profession, this was par excellent, and he was known throughout. And that is what I feel that I got. And one another, our senior advocates at that time used to say one thing, which I always kept in mind when I joined the bar, and my father also used to tell me that, look, his saying was that it is not the number of years which you have put in profession which will make you a good advocate, but it is the number of hours and minutes in those years which you put in profession, that is your hard work, which is going to pay you. So an advocate of 10 years standing may have devoted more time into profession than an advocate of 20 years standing. So 10 years standing, an advocate of 10 years standing may still do better, and that is what we see in the profession. And so journey was, and my father gave me the opportunities in the sense that you go and argue the matter, come what may, don't bother about it. So that gave me some from the beginning itself. When I was 2 or 3 months old in profession, I started arguing as a counsel, arguing matters in the court. But then that's the rest of the history. I could become senior counsel, and at that time, as you said, that many senior counsel of today used to brief me at that time. And judgeship was offered to me when I was, you won't believe, when I was 37 or 38 years of age. And at that time, one senior most judge of Delhi High Court, she invited me and to her chamber and said that we want to offer. But I then told her, you may not know what is my age. She said, what is your age? I said, I am only 38. She said, oh, okay, 38 is too young. You wait for 2 years at least. But by the time I was 40, then they said, no, the norm is 42 in Delhi. Then when at the age of 43, my name went, but at that time, norm became 45 because nobody was used to be made before 45. So I became judge at the age of 45, and at that time I was youngest in the country. And so therefore that is the journey till the time I became judge. And as far as judgeship is concerned, what I felt is that, again, if I say two aspects. One, there was another judge in Supreme Court at that time, Justice Santosh Hegde, and whose father was also judge of Supreme Court. He told one anecdote once. He's before becoming this judge, he was elevated to Supreme Court directly. Not he didn't come through High Court ladder. And he said that before he became judge of the Supreme Court, he was additional solicitor general for India in Supreme Court. So when he became that, we call it ASG. So he said that when I was offered that and became ASG, his father told him that, look, I do not know whether you deserve it or not, but now you have been made, prove that you deserved it and excel. So that is what I thought, that I do not know whether I deserve to become a judge or not, but now I have to prove. The God has given me this opportunity. I have become a judge. I have to be now as a judge, it is my duty that I have to serve the people of this country. And that is our constitutional duty. And therefore, I switched over as a judge, and I feel that the 20 years journey, and as you said, the judging in India is, you see, everywhere throughout the world, and particularly we are all Commonwealth, common law countries, and our system is almost the same. All have to decide the cases only, no problem. But at the same time, in India, there are some situations which are to some extent different from other countries, and because of which our judging and the role of judiciary becomes much, much more important. And because we are a country, and particularly because we got independent only in 1947, got ourselves constitution in 1950. But what happens is that it's a with large population. Number one, we are number two in the world in so our population is concerned. 1/6 population of the world, it is in India, second to China. Number two, so much of poverty and illiteracy in this country. And the subjugation of some of the communities over a period of time, hundreds of years, because of caste system, etc. So we have our own, what I say is social justice in this country, and how to create, and that is the ethos of our constitution also, that how to alleviate this poverty, how to make egalitarian society more equal, etc. We can only endeavor, of course. It is the function of any government as well, but judiciary also should contribute in whatever way, and judiciary is given a chance in our constitution in the form of judicial review. And therefore, in that sense, when you decide the rights of those lower caste people, when you decide the rights of women's rights, when you transgenders rights, I have given the judgment in transgender case, then rights of disabled, I have given so many judgments in disability matters, rights of minorities. So these are some of the challenges which, and if you see the history of Supreme Court, and I can say that yes, I have also given quite a few judgments in that direction, that Supreme Court today of India is known as one of the most powerful because of the power of judicial review, that we not only can invalidate a executive action but even legislative action if it is contrary to that. So therefore, and but at the same time, what is happening is, what I feel today is that on the one hand there is a lot of expectation of people, and it is because of corruption also in the society and at government level, etc. So lot of expectation of people when they come, and on the other hand, we are a country governed by separation of powers as well. You can't do everything in judiciary. So this poses a different kind of challenge as far as Indian judiciary is concerned. Sometimes I say that in the process we are in fact are judging under stress, where people expect much more, and when we want to give something, the bureaucracy criticizes us for over activism. So these are some kinds of challenges, but what I feel at the end, we have to maintain balance over the two, which I have been I mean, in my humble view, that I have been able to do that, and that is what people also say. So this is what
So,
I feel is my journey. Yes.
so it sounds like of your career to date so far, and we'll talk about what you're transitioning into a little bit later. But of your career to date so far, the one that gives you the greatest satisfaction is when your time as a judge, sitting in India.
Yeah. Yes.
Let's talk about what you're doing now and your transition. I know you are now transitioning to becoming an independent arbitrator, and you also you've been invited to sit on the Singapore International Commercial Court. So you now sit as a judge in Singapore as well in commercial matters. Let's start with the latter aspect of sitting in the SICC. Is this different to sitting in India? You spent some time talking about how judging in India is different because of all the social circumstances in India. Do you feel that sitting as an SICC judge is a different process for you?
Yeah, let me answer it in this way. As a judge in India, like first as a Delhi High Court judge and then in Supreme Court, of course, I have mentioned you about judging aspects and social justice and constitutional aspects only. But having said that, in Delhi, which is the capital of the country, and in High Court, we have a lot of commercial matters also. So not that we do only those constitutional matters. And in India, a judge is a generalist, not a specialist. We are made to sit almost in 20 years. I have sat almost on all jurisdictions, doing commercial matters, arbitration matters, intellectual property matters, tax matters, all kinds of taxation, income tax, indirect taxes, etc. So I have done all kinds of matters during this period. And in Delhi, being a capital, and so many commercial matters also were coming in Delhi, which I've done as a lawyer also and as a judge of Delhi High Court also. Same opportunity I was given in the Supreme Court as well, which is the highest court. And therefore, one thing good was that I had a good exposure as a lawyer and as a judge insofar as commercial litigation is concerned, that as well. At the same time, when you ask me the question about sitting in India as a judge doing these matters and sitting in SICC as an international judge, there's one difference I would still say. That is because of the reason that, look, in India, so far as arbitration is concerned, there's no good institution which has come like SIAC in Singapore or LCIA in London or ICC Paris. There's no such institution which have come up so far. And if you know, in SIAC itself, I think more than 40-50% cases are from India which are going there to SIAC. So therefore, international arbitration hub, that of course ad hoc international arbitration do take place ad hoc, not institutional. And because of the maybe a particular clause in the agreement where seat is of arbitration is India and the arbitration are chosen, and I'm doing those international arbitrations here, which I did as a lawyer also. But at the same time, we as judge in the High Court or Supreme Court, we don't have that exposure to the international scenario in which Singapore has. That advantage Singapore has. Of course, in Delhi High Court and Supreme Court cases come of international awards which are given, but they would come only for enforcements. Because if the property which is situated of the judgment debtor or against whom the award is passed in India, so enforcement would be. So in that capacity, I have done those matters. But now in SICC, this or SIAC when I am doing those arbitrations, and this is the exposure which I am getting, and I'm very frank. Of course, as we in legal profession, whether we are lawyer or judges, we learn throughout our life every day, and I am learning more insofar as very many nuances of the commercial arbitration with international flavor are concerned as a judge of SICC. That is one. I mean, advantage for sitting in SICC, which I did not have in India. So to that extent, yes, it is, I would say, yes, benefit to me. I'm still learning.
That's excellent. You've also talked about arbitration and international arbitration. And I know you're beginning now to sit as an international arbitrator. I mean, we've had the pleasure of sitting together twice, and it's a real pleasure for me to sit with you. And I'm interested, I'm curious, as someone who's had such a deep judicial career, do you feel the craft of judging is different from being an arbitrator? Would you approach a matter as a judge differently? Let's say it's a commercial matter.
Yes, yes.
Do you approach it differently as a judge and as an arbitrator?
I will say both yes and no. Yes, I mean, no, I'm saying it is not different in the sense, if there's a commercial matter of maybe whether only national ramification or international ramification. If you do as a judge, because in India also we have commercial courts, SICC is International Commercial Court, right? In a way, Singapore International Commercial Court at least is known, but we have domestic commercial court in India also. So therefore, if some matter comes before you as a judge, whether I'm sitting as a judge in India or I'm sitting as a judge in SICC, so you are doing as a judge. So you are deciding the almost the same thing because it is adjudication. Ultimately, at the end of the day, two parties are coming and you are deciding their positions, respective position, and the claims which are coming, how much they are entitled to. So you are adjudicating on the merits of the case. Same adjudication takes place when you are an arbitrator, as an arbitrator. So to that extent, it may be common, it may be same. But that is why I said no. But yes, there may be some difference as far as approach is concerned. Ultimate product may be same, but the way two things proceed, way court cases proceed, and the way arbitrations proceed, there's in the process, I'm now saying, there's a lot of difference, and as we know. And therefore, that makes somewhat the adjudication in arbitration proceedings somewhat different from as a judge. As a judge, you are more authoritative. As a judge, you are more formal, and you can control the proceedings throughout because you are the master of the court. But as an arbitrator, you have to give to some extent some leeway to the parties because it's a party autonomy which is to be accepted in the arbitration. And we say that yes, let the parties, but both counsel and as you know, many times in procedural orders here in arbitration proceedings, we leave it to the parties. If they are able to discuss and decide between themselves, so let them do so. We come in, we chip in only when there is a difference between them and we have to decide. Such things do not happen in court proceedings. In court proceeding, as judge, it's my authority and I'll pass the order. So therefore, the whole process from the filing of the case till the decision when it goes, it may be different, but ultimately end product would be same in both the cases. Your approach to decide the case, decide the matter on merits. Even in arbitration, you have to apply the law, which is prevailing in the case, you have to see the facts. So you have to analyze those facts, that evidence which has come before you, and on that evidence, what are the facts which are established, and on that, what is the law which is applicable to decide. Same processes in the as a judge also you do it, but decision making process, there are differences. That is what I would say.
I'm sure that when people listen into this conversation, especially maybe the counsel who are appearing in India, they might be interested to get your advice. Sitting someone who has such a deep judicial experience and now as an arbitrator, how would you say counsel should approach arbitration differently, appearing in arbitration differently from appearing in court? Any quick advice you want to give to counsel?
I think again, from my what I have said earlier, uh, in a way, it is the advocacy remains the same. But of course, the difference is in when it comes to original jurisdiction, because as arbitrator, we are adjudicating the matter as original adjudicator. In courts, it may be you are deciding as an appellate court where the award is already there and it is challenged, or like SICC, where the you may be sitting as in the appellate bench, where the single bench or the of SICC has passed the order and it is in appeal. So therefore, the advocacy may be different insofar as which jurisdiction you are appearing before. It is the original jurisdiction, or you are appearing at the appellate stage at that time. Because when it comes to the original, whether it is before the judge or it is the arbitrator, you have to be very, very, thorough with facts, because that is very important, because that is the first court or first authority, first stage before the arbitrator, where you are establishing the facts. What is my case, respondent case may be different, but that is what you are establishing. But when it comes to the appellate stage, then the facts, the appellate court won't go into the facts and the fact finding, etc. They will go only into the law and legal proposition which are settled, and that to jurisdictional aspects. So therefore, the advocacy before an arbitrator, in that sense, your role becomes little different, where you have to really hammer on the facts and you have to master the entire evidence, etc. And on that basis, you have to argue. Of course, you have to argue the law as well, no doubt about it. And when it comes to the court, then since the entire shift changes, because the award which can be challenged before the court is on very, very limited ground and jurisdictional grounds only. So therefore, it would be on in that sense. So what I will say is that the counsel who are appearing before the arbitrators, they know this distinction so well. But then the preparation has to be in that manner.
Before we run out of time, I have to ask you one more topic, which is, I think, tied to our current situation. So you're sitting at home, locked down in India. I'm sitting at home, locked down in Singapore. And I've spoken to you about this. I think you've had a recent experience of virtual hearings, as I have. Can you tell me what your impressions are of virtual hearings? And more importantly, do you think virtual hearings have a future even after the COVID restrictions have been lifted?
You see, what I say is that as far as my experience is concerned, so far it is good. First telling you in the context of, say, I've started many now domestic arbitration where I'm single arbitrator or where there's a panel of the arbitrators. But one thing which we have not been, except in one case of mine, where the case is at evidence stage and evidence is being recorded. But in other cases, as well in India, the lawyers are not agreeing for recording of evidence through video conferencing and virtual hearing on that, for various reasons, maybe for technology, etc. But what I feel is, as far as your question is concerned, that COVID-19 and this pandemic situation there is a silver lining behind it also. And that is that we are able to take help of technology in a big way. And so therefore, as far as internet are also concerned, wherever it is possible, and it is happening now in India in a big way, all arbitrators have started these hearings through virtual hearing. In courts are also today doing only virtual hearings only, because physical presence is not possible and it is banned because of lockdown, etc. So, but then there are many advantages, and in our judicial system, it goes a long way in case management and court management, also use of technology. In international arbitration, we have been using earlier as well. Like in the cases which we are doing together, up to now, the second case, there's no physical hearing which has taken place so far. So normally it takes place only at the time of recording of evidence or final arguments. Before that, everything is online, and if possible, they either teleconference or video conference with the parties. So going by that, I need not, because of paucity of time, say that what are the various advantages, etc., and what are little disadvantages also can be taken care of by technology itself. As I told you, in India, as far as evidence is concerned, there's some feeling, some fear that look, there may not be a coaching of the witness or witness some, but then it can be taken care of, which you also gave the suggestion, that 360 view of the camera. But now, going by the demand, in 2 or 3 centers in last 1 week I have seen, and there's one center called CODR which has come up, and they are providing these facilities which are ultra modern facilities comparable with anybody. They have taken it, I mean, learned it from Singapore, learned it from other countries, and they are providing you virtual rooms equipped with all kinds of facilities where there can be all parties are sitting, but if the 3 arbitrators want to have a separate sitting, want to go to a separate room, that facility is there. Separate virtual room, you can go there. And as a presiding arbitrator, I can, if I want only my other 2 co-arbitrators should hear, I can mute others, or I can go to a different room. So all that can take care of all these aspects. What I feel is that, yes, it should be a hybrid system which should remain even after COVID goes, wherever there are certain advantages of physical hearing also. So wherever there may be some situations where physical hearing becomes imperative and necessary. So therefore, we should continue with that. Of course, I can say you, okay, here I'm sitting on this virtual hearing, meeting you, but the advantage of then meeting you in person and hugging you and that kind of satisfaction I may not get. I mean, we may meet on this platform every day. Now, going to a particular restaurant, having coffee together, that kind of satisfaction we will not have. So, therefore, there are those physical hearings should go on. But whenever it is possible, virtual hearing, that is another thing. Now, because of COVID-19, economic recession which is taking place. So tomorrow parties will also, but it will generate more work also, even in arbitration. But at the same time, the parties would like the arbitration to be as less costly as possible. And so therefore, if we have to make it cost effective, so those stages which we can take care of through video conferencing and by virtual hearing and save the cost of the parties, that would be welcome by them. And as we know, if you see from the in last 20 years, 30 years, the way international arbitration has evolved, we have been experimenting and trying to improve upon the system from time to time. Till 7 or 8 years ago, 10 years ago, there were no emergency arbitrations. So we knew that, okay, that going to court for emergency orders may be difficult. So this is introduced. There were no system of med, etc. So over a period of time, we thought that no, mediation has some advantages, should be introduced in the system of arbitration as well. So in that sense, I feel that this step of technology at this is also a step ahead in improving the arbitration further, international arbitration further. And it should stay to the extent it should. I mean, it can be. But of course, it should not totally replace the physical hearing. That is what my take is.
Thank you so much, Arjan, for sharing all of these observations. It was a wonderful pleasure.
My pleasure talking to you, and it's always been.
Always a pleasure to listen to you. And as we say, I mean, my final 2 reactions to what you just said. One is, thank goodness that we always have the opportunity to continue learning. Now about virtual hearings and conducting virtual hearings. I mean, that keeps, I think, our minds so much more engaged and active, keeps our work so much more interesting. And I wholeheartedly agree with you that while virtual hearings work, we still need that human element, and I look forward to the time when we will be able to sit down together and have a cup of coffee together, or have a lovely meal together, as we have in Delhi.
Yeah, I'm looking forward to it. Thank you.
Thank you very much, Achan.
Thank you very much.
Thank you. Goodbye.
Nice talking to you. Yeah, bye.